This is The Prevalence of Sexual Harassment Toward Women in the Workplace by Camille, Taylor, and Anna. It was recorded on April 21st, 2015. Our introduction. With women advancing in the world of corporate America, it is not uncommon to hear stories in the news of women being sexually harassed. Sexual harassment can become detrimental and threaten the victim's job security, financial security, and emotional well-being. We feel it is important to educate our peers on this prevalent issue by providing knowledge and specific examples, especially as we all prepare to enter the corporate job world after graduation. Why did we choose this topic? At the beginning of the semester, our class learned about different forms of discrimination. We became interested in how women were affected specifically. Our group is comprised of 3 young women who are preparing to enter the professional workforce after graduation, and we feel that as the issue of sexual harassment is applicable to every woman and important for our peers to be aware of. We focused on 2 current cases. The first one happened in 2011 and is against UBS Financial Services versus Carla Ingram. Carla was 51 years old in 2011 and dealt with her supervisor repeatedly making comments about her body and other inappropriate things. Her employer, UBS Financial, fired her after she made the allegations, but the court went in her case, awarding her $10.6 million. The second one also was in 2011. It was Alfred versus Aaron Rentals. Ashley Alfred was a victim of extreme sexual harassment by her boss, with inappropriate sexual comments and sexual actions that were made against her. She was awarded $95 million, but only was able to claim about $40 million due to statutory limits. Some sexual harassment facts. 1 in 3 women between the ages of 18 and 24 have been sexually harassed at work. The highest percentage in retail, 42%, report being sexually harassed, while the lowest, only 21%, in healthcare. Sexual harassment in history. In U.S. history, slaves and domestic servants were vulnerable to sexual harassment since laws did little to protect them. Groups such as the Women's Christian Temperance Movement and labor activists worked to protect women from sexual harassment in the late 19th and early 20th centuries. That's when, in 1964, Title VII of the Civil Rights Act was put into place. Title VII applies to companies who employ more than 15 people and include both state and local governments. Circumstances such as unwanted sexual advances, crude remarks, and and requests for sexual favors are all considered forms of sexual harassment under Title VII. Where it is now. On February 12, 2015, the National Women's Law Center submitted a testimony before the Maryland House of Health and Government Operations Committee in support of House Bill 42, the Fair Employment Preservation Act of 2015. They believe that ending all forms of workplace discrimination, including harassment, is crucial to removing barriers in women's economic opportunity. There have been many cases of sexual harassment in the workplace against women. Courts have been awarding millions of dollars to women in these cases. Laws that prevent sexual harassment against women in the workplace are pretty standing and have not changed throughout the years, but cases are still occurring. Our case laws. Our first case that we focused on was Burlington Industries versus Ellerth. One of the most well-known court cases of sexual harassment, this case is about Kimberly Ellerth, who was being sexually harassed by her supervisor. Although she refused his advances and did not suffer any retaliation, she remained silent on her supervisor's conduct. Under Title VII of the Civil Rights Act of 1964, in a 7-2 ruling, the court upheld that employers are vicariously liable for supervisors who create a hostile work environment for those working under them. The second one was the EEOC versus Mitsubishi Motors Manufacturing of America. After a 2-year fight against sexual harassment claims from 350 female employees at the company's Illinois auto factory, Mitsubishi Motors was to pay hundreds of female employees a total of $34 million. Our scholarly analysis. We focused on 2 law reviews. Under Stanford Law, Professor Frank argues that the link between sexual harassment and sexual discrimination have been under-theorized by the Supreme Court. In the absence of a principal theory of sexual harassment, Professor Frank argues that lower courts have developed a body of sexual harassment law that goes against the legal norm of sexual discrimination. The second one we focused on was in the New York University Law Review. In Justice Smith's opinion, he believes that the new liability regime, in which liability standards are vary depending both upon the type of harassment and the harasser and the victim, are less than ideal. He believes that a set and uniform standard of liability needs to be upheld throughout all companies. Our own review. Like Frank, we believe that it is the why, not the what, of sexual harassment that needs a closer theoretical attention. The Supreme Court should take the next opportunity to impose a set standard of strict liability for sexual harassment by coworkers and supervisors. Like Justice Smith, we believe that establishing a coherent and uniform liability standard is important. And finally, our conclusion. In summation, we feel that employers and employees should continue to make strides to prevent sexual harassment. Through creating our presentation, we have gained a wide array of knowledge in regards to our topic, and we hope that our peers are able to say the same. From discovering our case precedents, both new and old, we have learned that sexual harassment is something that occurs way too often. With more harassment victims coming forward and filing complaints with various agencies, justice is finally being served to women across the country. As women continue to fill positions in corporate America, we hope the prevalence of sexual harassment starts to decrease. Thank you for listening to our presentation.